All right, so this is an interesting little deal we've got going on. Peggy Little is the senior litigation counsel for the new Civil Liberties Alliance, NCLA. And the Security and Exchange Commission denied the NCLA petition against the agency's illegal gag rule on targets of settled enforcement cases. Peggy, good to have you on the program.
Good morning. Thank you for having me.
All right, dumb this down for me and explain what these settled enforcement cases are and why this is important to me.
It is important because the SEC is cloaking or shrouding almost 98% of its enforcement practices in secrecy through this process. The gag rule that we petitioned the SEC to repeal was enacted in 1973. It's almost unthinkable, but for 5 decades, the SEC has demanded that anyone who settles their case with the agency must agree to a lifetime gag that they will never question the agency's charges against them. That is unconstitutional.
Completely, and it stood since 1973. But the SEC denies your petition against this illegal. How can they enforce something for so long? We're talking 50 years or more, right?
Well, people have a tendency to be sheep, I think. And, you're in a bruising enforcement action against the SEC, which can cost you millions of dollars. The average cost of defense goes well into the millions of dollars. And so when you reach a settlement, you're not looking at every little provision in the agreement. Moreover, and more troubling, the judge is not necessarily looking into the provision of the settlement because it's in what they call a consent order. And that consent I put in air quotes. And they require you to sign an order saying, I consent to be gagged, but it's required of you. So your consent is not even an issue. You have to sign it. They then incorporate that by reference in a final judgment that is presented to the court, but the court doesn't really, unless they go through all the paperwork, they don't really focus on this. So for many decades, people weren't even aware of this. When I published my editorial about it in the Wall Street Journal in 2018, there were many comments, and most of them were, "Are you kidding me? There's been such a rule like this for that long." Everybody recognizes it as
so. Here's a point that I want to make here, Peggy, is I'm listening to you as you're explaining this, and I appreciate that. The agency, when they make a settlement, the Security and Exchange Commission, with an individual or a company or however it plays out, they won't make a settlement without that gag order in effect, it says. And so they say that it's negotiated with the defendants, but it's not negotiated. It's either you take this or there's no deal. We'll give you this deal only if you agree to silence for life. Otherwise, we're taking it off the table. That's what's happened, right?
Absolutely. And there's a huge body of Supreme Court cases that say those are unconstitutional conditions. It's very well established law that the government cannot demand an unconstitutional surrender of your civil rights, in this case, your First Amendment rights, as a condition of doing business with the government. It simply cannot do that.
Yeah. And do you have, what happens if you violate the gag order?
Well, there's 3 things that could happen. We know of and have cited to the various courts cases where the SEC sees that someone has said something publicly, and they go out there and say, we demand a retraction, or we will reopen your case and sue you. The other thing it can do is move to reopen your case and re-prosecute you all over again, years after the prosecution, thereby defeating the whole point of settlement. And finally, because it's a court order, even though it's incorporated by reference, a judge can order civil or criminal contempt on you. And when the Cato Institute brought a suit over this same rule, they lost because of standing reasons. But in the court said, contradicted the SEC that said, well, all we would really do is reopen the case. They said, no, this is a court order. Civil and criminal contempt sanctions can follow for anyone who dares speak in opposition to the order. And therefore, that's why NCLA has brought these challenges in the cases that entered them uh, in order to get the judge to set aside the gags so that our clients do not risk contempt sanctions.
So, what do you think the chances are then? Handicap this for me, Peggy. What are your chances of success?
They're improving, is really what I would say. There is a powerful dissent called Unsettling Silence, My Dissent from Denial, by the SEC's Commissioner Hester Peirce. And it's a beautifully written dissent. It points out any number of things, including, even though the SEC says in its order that this is a negotiated term of settlement, even the SEC's own order admits later on that they require it as a condition of settlement. So it's internally contradictory. She calls them out on that and many, many other First Amendment violations.
And to me, yeah, and maybe this is not exactly in the same lane, but it's close enough to me where you have this Chevron doctrine that basically these agencies have almost unfettered, unlimited powers in front of the Supreme Court, not directly involved, but they seem to be first cousins here, where the government has complete control over people. I'll give you the last word. We got about 20 seconds.
Sure. We have two court advances, is what I would call them. Two judges on the Fifth Circuit Court of Appeals have said this is a prior restraint, and we do not think it will be long before the courts are called upon to address this question. And a judge in the Southern District of New York also publicly questioned and wrote a beautifully written opinion about why these consent orders have to be set aside. So we have many cases going. We will bring more. And I think our chance of ultimate success on this question is actually quite high because we are getting judicial recognition that
Well, Peggy Little, we appreciate the input. Thank you for the education.
Thank you so much.